So welcome again. I'm Mark Roby. I'm a HR advisor with Stephen Scone. I'm part of the firm's employment team based in Truro. And as you would imagine, we've been very busy supporting employers through the pandemic and the employment challenges that have been arising from that. Today, as you'll be aware, is a 30-minute session focused on key HR priorities at the moment. I'm going to cover 4 areas. Now, over 30 minutes, that'll be fairly high level. We're not going to dive too deep into detail, but I hope you'll find it useful for me to signpost key issues, developments, and where you can access further information and help. So those 4 areas that I'm going to cover are firstly related to COVID-19 and furlough and job support scheme and where we currently are with that. Going to talk about dismissals and the importance of 2 years service. Then part of the session on redundancy and restructuring specifically, and then finishing off with some time on home workers. Obviously, welcome questions. I would suggest with 30 minutes that we best deal with those at the end, but my contact details are on the slide there that you can see, and I'll put that back up at the end of the webinar, so you can feel free to follow up with any other questions. So I'm going to start with COVID-19 and particularly the coronavirus jobs retention scheme. We've been helping clients navigate the scheme and its changes since March, and we'll continue to do that as the position evolves. Obviously, things are changing all the time. One quick note from yesterday, you may have picked up that the principle of shielding of the most vulnerable people and employees is back, if you haven't already picked that up. But a quick summary of where we are then, as I'm sure you probably know the headlines here. So as announced on the 31st of October, the CJRS, or the furlough scheme, is now extended. So that was due to be replaced by the less generous job support scheme, or JSS, on the 1st of November. We're probably very much aware that under CJRS, employees who are placed on furlough leave received 80% of their pay, up to a maximum of £2,500 a month. So what's now happening? CJRS has been extended from 1st of November, not from today, not from the 5th of November when the new lockdown restrictions start, up until the 2nd of December, although who knows whether that will be longer. So the job retention scheme is effectively back to an earlier August variation of the scheme, with the government putting in the full 80%, with employers only needing to cover pension and national insurance contributions. Since July, again, as you're probably aware, employers have been able to bring back employees part-time if there's a need and furlough them for the rest. This will continue for businesses who can remain open. So that's what we call flexible furlough. And we have, in the last few days, been updating our templates and agreements around dealing with flexible furlough. So eligibility for this extension of the scheme through till the 2nd of December. Those employees must have been on the payroll by the 30th of October 2020. However, they don't need to have been furloughed before. And this is open to employers as well who have not previously made a claim under the job retention scheme. Now, on the payroll means that a real-time information or RTI submission must have been made for that employee to HMRC by the 30th of October 2020. Now, with the uncertainty, if an employee was made redundant on the 31st of October 2020, in anticipation of the original scheme ending, it is possible that they could be brought within scope of the extended scheme. But we've not seen anything, and we don't anticipate any requirement or or proposal that an employer rehires an employee to use the scheme. And obviously careful consideration should be given to doing that. Based on what we currently know, the intention is for the extended scheme to operate in the same way as before, with organisations being paid up front to cover wage costs. There will, however, and this is clear, be a short period where the government's legal terms and the systems need to be updated. And during that period, any costs will claimed will need to be paid in arrears. Of course, the job retention scheme isn't the only support that the government's giving. I'm not going to go through all of those, but that would include the £1,000 for every furloughed employee kept on until at least the end of January. So the question is, what happens when the current lockdown in England ends on the 2nd of December? What we know currently is that the furlough scheme will end at that point when England comes out of lockdown, the government says. And then the regions will then be classed into tiers as before, based on coronavirus risk level, and the job support scheme will kick in. So under that scheme, if a business has to close, so that's what we call job support scheme closed, due to local restrictions, it was announced that workers would be paid 67% of their wages, up to a maximum of £2,083.33 a month, with employers not having to pay towards an employee's salary. But news are reporting this morning that the Chancellor is expected to announce today that businesses closed by Tier 3 status at that point would get 80% of wages covered. So we're awaiting formal announcement on that, but that could be welcome for organisations that find themselves closed at that point. For firms that can stay open but only have enough work for employees to return part-time, we anticipate at that point they will be eligible for help under the open version of the job support scheme. And based on what we currently know, staff would have to be paid by the employer to work a minimum 20% of their hours per month. Let's wait and see, I think, later on in the month and as we get close to the 2nd of December as to what exactly those contributions are going to look like under those two schemes. I'd like to signpost you here to our article, and there's a link in the slide that gives the key information with a bit more detail on the scheme extension and also the flexible furlough arrangements, which we will update as we know more. Now, further guidance about the extended scheme is currently awaited. As at 6:30 this morning, when I last checked, that hasn't been published, but we are told to expect that this week. So please do stay in touch with our COVID Insights Hub and our articles, which is where we'll be publishing changes. What we do know, employers can still top up an employee's wages above the scheme at their own expense if they wish to, but there's no obligation. Employers will remain responsible for paying the wages in full of any hours actually worked by an employee. In terms of claims will need to be made for minimum periods of 7 consecutive calendar days. But we are reassured that there appears to be no gap in eligibility for support between the previous end date of 31st of October and the extension of the scheme from the 1st of November. One thing to make sure you're looking at is to ensure that you have either a new or an appropriate furlough agreement in place with each employee. So, for example, if you had a previous furlough agreement, was that time limited up to 31st of October or earlier, in which case you advise to update those agreements. But do get in touch with us if you need any help with that. Obviously, around the country, there are urgent decisions being made in light of this development. For example, how should any redundancy processes that are already in motion be handled? If pay has previously been topped up for furloughed employees, is that still possible? What level of part-time work could be offered and afforded? and all the careful communications that are required around that. We're continuing to advise many organisations on the various considerations here, so please do get in touch if you'd like any assistance with any of this. So moving on to dismissals and the importance of 2 years service. This is one of the most common queries we receive to our advisory helpline around HR issues, and even more so during the pandemic as businesses inevitably face downsizing and restructuring. Because it's such a popular topic, I'm going to cover it again today. My colleague, Chris Morse, has authored a very popular article that I recommend to you, and there's a link there on the slide. Now, of course, the pandemic has led to numerous job losses, and despite everyone's best efforts, that's something that might continue for some time to come. Now, for some employers, inevitably, staff with less than 2 years service are seen as low-hanging fruit at a time requiring job losses and where there's an understandable wish to get things done quickly. Now, generally, someone needs 2 years continuous employment before they can complain to an employment tribunal that their dismissal was unfair, either based on procedure, i.e. lacked proper process, or substantively unfair, for example, due to too severe a sanction. But it's vital, if you don't understand this already, that there are still claims that can be made by an employee in the first 2 year period. We tend to refer to those as day one claims. And there are basically 4 types of day one claim that I want to run through with you and make sure you have a good understanding, and that will help you if you're making difficult decisions about redundancies at the moment. Number 1 is automatically unfair dismissal. And for most types of automatically unfair dismissal, claims can be made without 2 years service. An example, a dismissal for a health and safety reason. The law recognises that you shouldn't need to serve 2 years service to bring such a claim. In the current environment, this could potentially arise with an employee who might have a live complaint about the management of COVID risks in the workplace, perhaps. Secondly, discrimination. That's a very common type of claim. The Equality Act protects discrimination regardless of their length of service. Now, there can often be crossover between the automatically unfair dismissal and discrimination. An obvious one, dismissal for reasons connected with pregnancy or maternity, would be automatically unfair and would also be discriminatory. The third type of claim I want to highlight is whistleblowing, and that's also very common, both in terms of an employer's risk assessment of making a dismissal or not, and something an employee with less than 2 years service may try to assert to try to protect themselves. Now, dismissing an employee for making a protected disclosure, commonly known as whistleblowing, is unlawful. So an employer who responds to a whistleblower by dismissing them or even just treating them detrimentally, it's very easy to find yourself on the wrong end of a whistleblowing claim. Now, we might be dealing with advising a client on perhaps that employee who is making constant complaints about perceived health and safety risks. Now, making that dismissal might not be the risk-free dismissal that it seems at first glance. So that's something to really consider if you're looking to genuinely have to cut employee numbers, but you've got employees who are complaining about the risks of their health at work during the pandemic. Now, remember that for discrimination and whistleblowing claims, compensation is uncapped. So you have to think very seriously about the risk before you make decisions. The fourth one, just to touch on briefly, is breach of contract. With dismissals of someone with less than 2 years service, claims commonly arise in relation to unpaid wages, in particular notice pay. So if you're contemplating making such a dismissal, always make sure you know what notice is required under the employment contract and what other contractual obligations are in place. So practical advice for employers. We advise that even where you're confident in a decision to dismiss someone with less than 2 years, it is still worth meeting with that employee to discuss the situation. That's your opportunity to set out your stall in terms of the valid reasons you have in your mind to perhaps dismiss, for example, performance in their role, and to see what the employee has to say in response first. You're well advised to hold back on communicating any decision on a dismissal until after hearing what the employee says in response, especially if the dismissal is prompted by poor performance, in case there might be underlying causes, and only then decide whether to go ahead with that dismissal or to perhaps defer it and take some further advice because of the possibility of a day one claim. A common example we may see might be an underperforming employee who discloses, for example, anxiety and depression as a potential cause for their performance issues. That needs careful handling and risk management. Carefully managing the dismissal of an employee with less than 2 years service with a potential day one claim is much less inconvenient than rushing ahead to a dismissal and then having to defend that decision to do so later. We see many cases that are undoubtedly more expensive and more stressful in the long run. So there are routes, of course, to dismiss someone with less than 2 years service at low risk. But it's foolish to assume that you have carte blanche to dismiss at will, certainly without having a careful consideration of the risks. So please do take advice before making any dismissals. I'd like to now move on to redundancy and restructuring. As we've said, obviously the pandemic has already led to a number of many job losses across the economy. Now, where a genuine redundancy situation exists, to not use the current options that we have available, i.e. to use the furlough scheme and or to put employees on short-time working under the job support scheme when that starts, will not mean that a redundancy dismissal is necessarily unfair. There are situations where some jobs have, in the current climate, have genuinely been eliminated and workplaces have been closed. However, if you're going to make redundancy dismissals final, you should be able to show, to protect yourself as a business, that you've considered furlough and or the job support scheme when it starts as an alternative to redundancy for each type of role you consider redundant, and to have some documenting of the reasons why you felt it wasn't suitable in the particular circumstances of the case. Now, see, employers realise that making redundancies can impact productivity and morale of the remaining part of the organisation, as well as being extremely hard for the employees affected, particularly when the job market is so depressed as it currently is. So is there any good way to handle these difficult situations? I've included here some links to several resources we've published on this subject recently. These include my colleague Verity Slater's article on tips for handling redundancy in an ethical way, in a way that also minimises the risk of legal claims and manages your reputation at this difficult time as far as possible. A few points I'd like to highlight from those. Before making any final decisions, do a final check that you've looked at all the possible other options, evidence that you've done that, whatever those options may be in your own organisation's context. Make sure you take specialist legal advice to get the planning and process right. I would say that, wouldn't I? But we do see unfortunately, some employers fall down on process where their rationale for the actions they're proposing to take are otherwise completely sound. Where practicable at the moment, do keep people on furlough or the replacement schemes when they start, but obviously balanced against the or any business advantages of making those redundancies earlier. It almost goes without saying, but the tone of communications here is going to be really important. To be, on the one hand, very honest and open about the challenges you're facing, but also at the same time being supportive. And remembering that with redundancy, no final decisions are made on who is going to be made redundant until the end of the process. If you were in front of a tribunal, you've expected to show that that consultation process was genuine. Finally, the aspect around support. On the one hand, for employees, and this is part of a fair process that should hold up in a tribunal, make sure they are given time to process proposals. For example, we would always recommend 48 to 72 hours notice of any formal consultation meetings, and are given time to ask questions. And where possible, if you can you arrange other support such as outplacement support, financial advice, counselling? Can you do anything to help your employees in the transition to new work? And the often forgotten one is support for you and managers involved. Making redundancies is emotionally tough for anybody involved. It's really important to give training and support to those managing this. And obviously, as an experienced legal team, we can support, guide, and keep you on track as part of that support. For example, we commonly are asked to produce preparation notes for managers who aren't used to doing this, which they can use almost as a script to guide them through a difficult meeting. Ultimately, our mission is to get the result you need to support your business and support you at the same time. So in the final part of the session, I want to talk about home working. Now, back in March, many of us had to move back to home working with very little preparation. And of course, many organisations have adapted incredibly successfully to that. But with the advice to work from home if you can set to continue for some time, where are we now and what do we need to make sure we do in relation to home working staff? Thus, in terms of health and safety, I'm expecting to see more issues bleed out into the advice that we're giving and questions we're getting as employees have been perhaps making do at home somewhat for 6 months plus. Now, the Health and Safety Executive has a raft of useful resources for helping to assess risks of home working, so I would definitely encourage you to use them, and there's a link on the slide. The employer's obligation, as ever, is to ensure your employees' safety and not to expose them to risk, either actual or potential, and to do all you reasonably can to set up a safe system of work and ensure that's implemented. And that duty extends to employees when they're working at their own home, at least insofar as their workstation and desk area is concerned. Now that can be pretty daunting. The practical advice is have an overarching risk assessment in terms of home working, share that with staff, task your own employees to carry out their own assessment. They can send in photos or videos of their workstation and have that dialogue with them about any difficulties they're facing and review and deal with issues that come out of that assessment. Secondly, in terms of home working securely and data protection, of course, that can raise all manner of potential data protection considerations. The Information Commissioner's Office have published 10 practical tips for how to work at home securely. So do review those if you're not already aware of them. We'd also advise, as employers, you carry out some form of privacy impact assessment to consider the security of data when people are working from home. and we work alongside data protection specialists who could assist with that. Potentially there's some questions around contract of employment. Might contract of employment need to be updated? You need to make sure that your contracts are fit for purpose and reflect the reality of the arrangement in place. And there are various clauses within a contract that could be affected by home working, from obvious ones like place of work, but also things like expenses. Even occasionally we'll get questions about the employer's right to enter a property in terms of carrying out health and safety risk assessments or to recover equipment, although that's quite unusual. And finally, in terms of policies, home working, to the extent we're now doing it, requires you to review your existing processes, and that may need you to develop new policies or adaptive policies to limit the legal risks. And again, that may seem a daunting task, especially at the current time, but we know that many organisations are reporting to us the benefits of increased home working and how it may be able to reduce overheads in the longer term. So away from the legal side, we talk about the new normal, don't we? Some questions in terms of home working. Are you equipping or training your leaders or managers to manage people effectively under this new model or various models you may be operating, and for the staff to work effectively under that? I'm aware that Ruth Gawthorpe and her team are running various sessions today around that whole topic of smart working that you might find helpful if you're listening to other webinars today. Clearly, the best organisations will listen to and engage with their staff in ways that you may not have done before March, recognising that home workers have been isolated from family, friends, colleagues in a way that we've never seen before in the UK. And that separation from society will undoubtedly have had its own negative impact on individuals' mental health and well-being. I'm also reading lots of concerns at the moment about, I've seen the phrase virtual presenteeism. Of course, many people are feeling the pressure to work like never before and to be available like never before. And of course, as an employer, you need to have a look at how you're managing that risk. You'll need to be in some way able to monitor the hours that employees are working to ensure that they are not excessive. And are you assisting managers, for example, when people are having video meetings, are they looking out for visual cues that might indicate that someone is finding things particularly difficult or under too much pressure? So a couple of links to further articles that provide further information on that topic of home working that you might find useful if you want to look at some more detail on that. So as we come towards the end of the 30 minutes, we're constantly publishing new information as the situation evolves, not just in terms of HR and employment, but across our firm as to how the pandemic is impacting on all different aspects of the law. So, if nothing else, do please check in on that Insights Hub on a regular basis. It's the best source of information as we make updates. So I've mentioned some of these articles, but there are various others there that I've listed that we've published recently specific to employment, which you may feel useful. So in summary, thank you very much for your time this morning. I hope you found that useful. If it's raised any questions or issues for you, please do get in touch. My contact details are there. I'm also very happy to stay on the call if you have any immediate questions that you want to raise within the group. Please feel free. Likewise, you have my contact details there if you want to get in touch following the session you're very welcome to do so. Hi, yes, I have a question from Saab.
Hello, I just wanted to ask you quickly, is there any guidance about what constitutes work from home if you can? It just feels very vague. So just as a very random example, we've got one employee who drops his child off to a nursery, and it makes more sense in terms of travel and everything else for him to just then go to the office and work, and then pick up his child at the end of the day. Would that constitute working from home if you can, or would we be breaking the guidance if we let him work from the office under proper, safe and secure processes, following all our processes that we've put in place, obviously?
Yeah, I've not seen any guidance that is as specific as that in terms of almost that geography point of, I suppose ultimately that's it's an efficiency point and it's a convenience point, isn't it? I think where we are in terms of a national lockdown for England currently, I think my inclination would be to say, it's work from home. Now there are specific guidance in certain sectors. So, for example, in our own area, where the courts are continuing. So the Law Society has published some specific guidance for us as a law firm, and of course law firms across the country, in terms of finding that balance between working from home if you can, but also things like the residential property market that's continuing, and situations where you might have to process legal documents, and that very much being the exception. So while I haven't seen a specific answer to your question, I think the expectation in the current lockdown would be that person should still work from home if they can do their job from home.
Okay, thank you. Thanks very much.
Okay. Any other questions at this stage? Okay. In that case, I will draw the webinar to a close. Thank you once again. I hope you found it useful, and please do get in touch if you have any further requirements.
Thank you very much. Thank you.
Thank you. Bye now. Thanks.
Bye.
Bye now.